Passage 11 Start. The relevant facts involved in the instant appeal are that 1. Mahmoud Abbas filed suit number 965 of 2003 for declaration, specific performance, possession and permanent injunction. It is further stated in said suit that that though the appellants were necessary and proper parties to the proceedings, but the respondent Mahmoud Abbas did not implead the appellants as defendants. However, upon having knowledge of the pendency of the said suit, the appellants moved an application under Order 1 Rule 10 CPC for impleading them as defendants in the said suit. In the said application, it was urged by the appellants that they were grandchildren of late Nur Muhammad, who died on 2/10/1960, left behind the agricultural land in Deh, Samruti district, Mirpur Khas. Details whereof are available with the District Officer, Board of Revenue, Mirpur Khas, as well as Board of Revenue, Sindh, EP Wing, Park Secretariat, Karachi, and Secretary Rehabilitation, S&R, Central Record Office, Lahore. The appellants further alleged that Sayyid Hamid Rahmani, son of Mahbubul Haq, and others have manipulated, usurped the land of Nur Muhammad. SL number 211, page 37, dated 14/11/1995. Nabi Baksh, SL number 51, page 11, dated 15/12/1955. Hashim Ali, SL number 406, page 67, dated 21/12/1955, to the detriment of the genuine and legal entitlements of the legal claimants. In support of their claim, the appellants filed entitlement certificate regarding rural urban abandoned area in India. Appellant number 1 submitted an application to the Secretary, Board of Revenue, Wing 79, Park Secretariat, Karachi, regarding illegal claim of land situated in Deh, Samruti, Taluka Degree. Appellants placed certain documents before the court showing that said Nur Muhammad was entitled to some or all of the subject property on the basis thereof. As such, they claim that they were necessary and proper parties to the said suit and ought to be joined as defendants. The said application of the appellants was heard by the learned single judge, who, after hearing the arguments of the parties, dismissed the said application of the appellants void order dated 9/8/2011. After dismissal of the said application, the appellants filed another CMA number 9959 of 2011 seeking review of the said order, which also met the same fate. Hence, the appellants through the instant appeal have impugned order dated 5/10/2011. The appellants have argued that the learned single judge has passed the impugned order, which is based on erroneous assumptions of law and facts. It is further argued that learned single judge has failed to appreciate the submissions of the appellants in respect of the property in question, which was based on substantial evidence, and the same could only be proved during trial, but the learned single judge did not afford any opportunity to the appellants to prove their inherited interests in the suit property. He further argued that it is the case of the appellants that they are grandchildren of late Nur Muhammad, who died on Though the 1960 left behind the agricultural land in the Samruti district, Mirpur Khas, details whereof are available with the district officer, Board of Revenue, Mirpur Khas, as well as Board of Revenue, Sindh, EP Wing 79, Park Secretariat, Karachi, and Secretary Rehabilitation, Central Record Office, Lahore, full stop and close.